This conference will now be recorded.
Hello and welcome. My name is Yasir Gulfraz, and we will discuss today contract law assignment, final assignment. Uh, Basically, when you start assignment, you should know that what you need to write and what are the contents of assignment. So today we will discuss a bit about how to write an assignment and what do you need to write in the proper assignment. So here is the contract law assignment. Which says that you are a trainee solicitor, BL, LLP. Your supervisor has asked to advise on a number of contractual matters relating to one of the firm's client, Mr. Wilson. So, sales of paintings. Last year, Mr. Wilson inherited two paintings from his uncle. He does not particularly like the painting, and on Monday, places the following advert in a local newspaper. So for sale to painting, 1950s, price negotiable. The advice contains a photograph of each painting and Mr. Wilson email address. Mavis sees the advert on Tuesday. She thinks that the painting are by the famous artist Dale Salvadori and immediately send an email to Wilson saying that she will pay £200 for both of them. Wilson emails back on Wednesday morning saying that he will each £200 per painting and that Marvis should communicate her decision to him no later than Friday morning. On Wednesday evening, Wilson receives an email from Polly. It states that Polly will pay £500 for both painting. Wilson responds to Polly email straight away saying it's deal. They are yours. On Wednesday evening, he also sent an email to Morris, information her that the paintings are no longer for sale. Morris' email account is hacked on Wednesday morning and she cannot send or receive an emails. She sends a letter to Wilson Thursday morning saying that she is happy to pay £400 for both painting. The letter is received by Wilson on Saturday morning. By this time, Wilson has discovered that the paintings are by Dale Salvadori and refuses to sell them. Both Mavis and Polly each claim that have a valid contract with Wilson for the sale of the painting. So you need to produce Wilson written advice on each of your supervisor to consider in the cases of Mavis Wilson and B. Polly versus Wilson. Using the information provided, you must ensure that you are distinguish between offer and invitation to treat, identify and explain the regular rules applicable to the acceptance of an offer. So yeah, this is the first task where you need to distinguish between an offer and invitation to treat, and also yes, yeah, there is a you need to uh, distinguish between offer and treat, an invitation of offer and an invitation to trade. So before you start your assignment, which I will discuss in a bit, but you should know that what is the here you will write, and we already in our previous lectures we studied that what is the offer and what is the invitation to trade. So before you start your assignment, you should know that what is the contents of your assignment and what is the your uh, assignment requirements, and you need to put some case laws as well. So advice say before you start your assignment, you should know that what is the distinguish between uh, offer and invitation to trade. So contract is an, as we studied before, as an agreement the contractor and the client which is binding the law. So client defines the project objectives, schedule, and the budget. So uh, when tenders have been submitted by the contractors, the winning tender is selected and a contractor project is entered between the client and the contractor. So this is and but you need to write after distinguish between offer and invitation. What is offer and invitation? Obviously, you know that offer is a statement of the terms which the client is prepared to be contractually bound. So also you should know that we discussed previously how to terminate offer. You can write bit about terminated or revoked it, failure if the client making the offer dies, or failure of condition. So reasonable period of time has elapsed, so a time limit is specific on the offer made. So next, also you just write a bit about acceptance. Next one is a fully binding contract is only formed and it an offer is accepted. So we discussed about acceptance is a final and unqualified acceptance. We discussed in our last session, we discussed about unqualified and qualified uh, acceptance. So next is you should write bit about invitation to treat. An invitation to treat is a different to an offer, obviously, as it only invite the party to make an offer. So uh, also there is a task that green cottage and related. Wilson wants to open a first I will explain every task, and I'll tell you what to write and what you need to write within the assignment and how to do it. So then I will explain a bit about contents of assignment. So green cottage uh, and related matters. Wilson wants to open a boutique and boutique hotel. He buys green cottage for £300,000, and on 1st February hires a construction company build it perfect or carry out the refurbished. So under the agreement, built a BIP needs to complete the works by 1st May for the fixed price of £50,000. On on 1st May, BIP informed Wilson that they are experiencing financial difficulties, and unless he pays them an extra £20,000, they will not complete the work by agreed date. Wilson is furious. Uh, if the work is not completed by 1st July, he will need to postpone the opening of the hotel and cancel the booking. Therefore, reluctantly agrees to pay BIP the additional £20,000. BIP complete the work by 1st of July. So here you must continue to provide written advice in the case of Wilson and BIP for supervisor of the consider. So written advice for Wilson and B using the information, assess the requirements of valid consideration, analyze the develop of the doctrine of duress. We discuss about duress, that how to finish the contract, and in under which term you can finish the contract. So uh, you also to get a merit grade, for a merit grade, make notes for a meeting which that critique the significance of practical benefit of consideration. And distinction grade, you should assess the limitations of William versus Roffey brothers. This was the case law we discussed previously in relation to promise accept less. So Wilson, the B part B of assignment is Wilson orders £30,000 for some new maid to measure for furniture for the boutique hotel from Dakia. Uh, Dakia is to deliver. For Dakia is to deliver the furniture by uh, just give me a second. Yeah, deliver the furniture on 1st July. Dakia delivers the furniture on schedule, but none of it is on agreement dimensions. Wilson sent it back and wants Dakia to refund him £30,000 he paid for it. Dakia refuses to refund, brings his attention to the following clause contract contained on the last page of the contract, which was duly signed by Wilson. So that there was a clause 47 which was saying that under no refund under any circumstances. So Wilson now finds a local company that can deliver furniture in time for the opening, but it only has sufficient furniture in stock to finish 3 of the 6 bedroom. Wilson decided to go ahead with the opening despite the fact of only 3 of the rooms to hire. So on the previous talks, you should to get married, take the significance of practical benefit as consideration. Okay, and for distinction, you should assess the limitation of Wilson versus Raffe brothers in relation to promise to accept less ACIDE. So you need to put some case laws as well. You look at the case law. If you go to, as I said to you, West Law Library or Google Scholar, you check, you can get Williams versus Raffe brothers. So here is the task. Your supervisor now wishes to draft written advice to the Wilson versus Dakia him for uh, him to consider in this communication you need. So first you need to explain the terms and representations. So terms and representation, we discussed previously what is the difference between terms and representations. So basically that we discuss our explain the difference between terms and representation. We discussed in our previous you know uh, lecture that what is the representation. Basically its representation is a statement which relates to matter of fact or present intention made during contractual negotiations, which the parties do not ordinarily intend will become a contractual, not ordinarily. So intent will become a contractual term, but which may induce another party to enter into a contract. So next one is asking that conditions, warranties, and uh, in nominate terms. So we discussed before as well conditions versus warranties. So warranties, conditions versus warranties, that basically condition, that condition must be performed prior to the completion of another action. So so if you're not filling your conditions, you can get a big damage, or you have to pay a heavy compensation. So warranty by contract is essentially a promise that the facts buyer give a sellers gives, that sellers and everything is genuine or original. So next one is talking, and make sure that when you write an exam assignment, you should know that what is difference between explain, distinguish, examine, distinguish, assess, or compare. Command of verbs are very important, which I will discuss with you in a bit. So our last session, and we discuss liquid and unliquidated uh, damages. So basically, liquid damages or an aggregate damages is a provision in a contract that fixes the sum payable as damage for a party breach. Okay. In other hand, unqualified damages for a party's breach which have not been that pre-estimated. So basically unliquid damages can be defined the sum of money that cannot be foreseen or assessed by the fixed formula. You just need to write a bit about definition between difference and between unliquid damages and liquid damages. So liquid damages, you can you know that there are, if you look at your slides on, see my previous lecture, where there you can find both definitions. So liquid damages are presented in certain legal contracts, so as an estimate of otherwise intangible to hard to define losses to one of the party. So how to assess the aim of damages? You can check that 5.2, how that you can assess damages in the contract law. And also you need to compare the contrast, the difference measures and used of assessing damages. Uh, then in order to achieve a distinction grade, you must in addition analyze the court approach to interpretation and validity of exemptions clauses. So assess the amount of damages can uh, assess the amount of damages that can be claimed for a specific breach of contract. Next one is basically journal how to assess. We already discuss in our previous lectures, but damages are meant to place the claimant in the some position as if the contract had been performed. So then damages are usually awarded for expectation loss or reliance loss. So measure of damages in contract law. So that's mean that damages awarded of breach contract law. So generally the purpose of an award of damage for breach of contract is compensate the injured party. Next one is says that a day before the opening, he received a booking request for Robert Melford for a 2-night all-inclusive stay. So when Robert arrives at the hotel, Wilson is convinced that he is a famous footballer player, Ronald Massino. Using analyze a reception, Wilson has displayed a few antique items for sale. On checking out, Robert select vase for the display and asked whether Wilson is willing to take a check for it. Wilson says although usually he does not take checks as he is famous footballer star, so he will accept a check. To this, Robert smiles and gives Wilson a check for £500. Wilson accepts the check and gives the vase off to Robert. When he goes to bank to cash in the check, he is informed that the check is forgery. Wilson manages to trace the vase to Cam, who had paid Robert £700 for it and refuses to give it to Wilson. So, in the written advice to Wilson, Sandra, we uh, here you should that identify. You need to put some case laws as well, but you need to just here, if you look at here, uh, task, it's a task 3. uh, Explain the, yes, here you need to, yeah, in written advice to Wilson and Cam, using the information provided, you must identify the elements of actionable representations and difference between fraudulent, which we already discussed. If you go back to your first and second learning outcomes, you will find out the difference between fraudulent, negligent, and innocent misrepresentations. Okay. fraudulent. Obviously, person knew and he did fraud. He knew that he's doing fraud. Negligent, he did not know that he's doing fraud. And innocent, he completely unaware. So, in order to achieve a merit grade, you must examine the remedies available for fraudulent, negligent, and innocent misrepresentations. You can write difference, and you can also write some remedies, or that how to compensate fraudulent, negligence, and innocent misrepresentations. Means that remedies. So contrast the effect of misrepresentation and mistake on contract. Then next one is 2 days before the hotel is already ongoing opens. Sandra, who was contacted by Wilson to use sing at the opening night, phones to say that she will not to be performing because she has broken her leg. So and cannot travel. Wilson demands that Sandra returns the 2,000 he paid to her for the performance. So there was a talk in the written advice for Wilson and Sandra. You must ensure explain the different ways in which a contract can come to end. So you need to write. That we already discussed in our previous lecture, that there are some conditions and specific circumstances where can contract come to an end. So you need to write different ways that how to contract can come to an end. And also there is a frustration. Examine the doctrine of frustrations. That if you read about, there is one, that frustrate way is frustration. So you need to examine the doctrine of frustration. So this was the assignment requirements. And if you go down, so here are different criterias that how can evidence must be properly presented for the targets and learning outcomes and assessment criteria. You need to write some obviously case laws. So in task one or all tasks, that you must be appropriately presented for the target audience provide in the scenario. Also, learners must ensure that they take account on the command words stated in the AC. Learners should produce details notes that different between an offer and an invitation to treat. Then you should identify and apply relevant case laws which are very important. So including the journal rule in relation to the adverse. Okay. So next, that like he's also talking about uh, should consider the issue of whether Morris has made an offer to Wilson and differentiate between acceptance and counter offer, and the effect of a counter offer on the original offer. So discussing the applications of the rule in Hyde versus Wrench. So also you should also detail the acceptance of an offer, including when acceptance by post is valid and criticism of the postal rule and its limitations. So also cover, revocation of an offer and the circumstances when an offer is validity revoked. And notes should be well structured, easy to follow, and apply relevant case law. Must be, apply, any relevant case laws. So if you have any issue, uh, you can drop me an email, and also you can go to the Westlaws library and you can see relevant case laws. So learners should produce also detailed structured notes, identify the constitutions and explanation. The rule is Storer versus Manchester City Council. Uh, if you go to I'll tell you in a bit about case laws. They should explain the what constitute acceptance by instantaneous modes of communication, discussing the application of intros. Also consider whether emails are an instantaneous form of communication as discussed in Thomas versus BP solicitor. So also ensure that account of the command of verbs. I already discussed earlier that commands of verbs very important. You know, you should know that what is meaning of explain, evaluate. That is difference between distinguish and uh, identify. So you should go to if you search that and write it down that what is difference, what are the command of verbs. You will see that you will get uh, something from there which can explain you about command of verbs. So before you start your assignment, you must read about command of verbs. So written advice should give a clear explanation of terms and representations. So differentiating between them and between conditions, warranties, and uh, innominate terms using examples relating to the given scenario. So you also identify the contractual terms for the scenario, consider the source of them, should determine mine from this the contract that exists for sales of good, and identify the terms of the contract. So uh, also express terms as well as terms implied by the Sales of Good Act 1979, which we discussed yesterday. uh, Merit answer will consider the requirement of the validity of exemptions clause interpreted by the court's reference, incorporation, common law interpretation. So uh, also, you should produce notes that consider whether Wilson will be able to claim the waste from Kim if the contract between Wilson and Robert is void on the ground of mistake, to establish whether there is an operate mistake as it identified. So I will suggest that you should go through the all, your LO5 and LO4, and go through the case laws as well. Written advice should be detailed the different ways in which contract can come to end, as discussed earlier, that you should note that how to contract can come to an end and under which circumstances and conditions. So in particular, how and when a contract can come and end because of frustrations, using relevant case examples. So frustration should be defined, and learner must identify when a contract can be frustrated. So what the effect of this is on the party's obligation under the Law Reform Frustrated Contract Act 1943. So that's it. This was our learning out, assignments, requirements, and I just explained a bit about, what you need to write within the assignments. But also, please, go through the learning outcomes and make sure that your case laws, go through the case laws. So when you start writing an assignments, first of all you just start with the which assignment is it, contract law, then submitted by law school of UK Versity will be your first page. So after that you can need to make an uh, table of contact contents. You can write introduction, little bit introduction of where you can explain that contract and the you know assignment, about contracts, terms of contracts, and these kind. Then when you write your task one, uh, you just go through the AC 1 and you start writing with a distinguish between offer and an invitation to treat. So just little bit explain about treat, and then come to the offer, and give some uh, example, case law example. So you can, if you go through your learning outcomes or slides, you can take, if there are case laws, you will find out under treat and uh, uh, offer and an invitation to treat. There will be a case laws, you can write same case laws, or you can even copy and paste that case laws as well. So when you come to the case 2, you need to, task 1, in task 1 and task 2. So in one, you know you need to produce written advice as well on each issue for your supervisor you consider in. So this distinction again, that, as I said to you, that difference between offer and invitation to treat. So you can write definition by, offer Smith, and obviously you will use a reference, Harvard reference system, and you need to give your reference. Like if you write a definition of offer or invitation to trade, you must give, name of the you know referee as well. So next, you also need to identify the explain the legal rules applicable to the acceptance of an offer. So in you should write, when you write, and that legal rules applicable to the acceptance of an offer, what are the rules of and how to applicable to the acceptance of an offer. So just write a definition of acceptance and offer and rules, and then you can write. And as I said, you can copy and paste case laws from learning outcomes. If you go to the lecture or slides 2 and 3, 1, 2 and 3, you can get from there. So also you must continue to provide written advice in the case of Wilson versus BIP, which I just seen there. And for that, for my consider that supervisor to consider in the written advice for a Wilson BP, using the information provided, your must ensure that assess the requirement for a valid consideration, or 1.3 consideration. So also analyze the development of the doctrine of juris. uh, Here you will see AC 3.3. So uh, uh, that when as per now we discuss certain points of that law. So you know that you must be prepared for the meeting, as the uh, obviously to me will high expectation of the discussion. But for a merit grade, make sure that notes of the meeting which critique this, as I discussed previously, the significance of practical benefit as a consideration. So ACIMI for a distinction grade, you notes must also assess the limitation of Williams versus Rofe Brothers 1991 and relation of promise to accept the ACID1. So you just need to write, and conclusion also you need to give a bibliography. Like when you write a bibliography, you just write surname and first name of the writer, like a Smith John 2019, contract law London Green, you know uh, 2019 again. So you can when you write in about invitation to treat, so you just must give a example by case laws. So there is a case law for invitation to trade. If you go to your learning outcomes, 1, 2, 3, as I said, there is a Cornell versus Carbolic Smoke Bells Company 1893. So the defendant were the manufacturer of smoke balls, which they claimed could prevent flow. I believe so. So you just go through that case laws, and you can even copy and paste, or you can write into your own words into the invitation under the heading of invitation to treat. So make sure three main things are: what first one is the command of verbs. You should as I said, you should know what is the difference between evaluate, explain, analyze, or evaluate. So you go through with every single and each command of verb. So also that within the paragraph references, you very carefully read bit about Harvard reference system and give references. Then end of the even if you write a direct code, still you need to give a reference, and also you need to that go to the bibliography. You just need to write primary sources and secondary sources. Primary sources like book and articles, and secondary sources you can write about you can give websites references. That's it. And then case laws, as I said, if you go through the your learning outcomes slides, where the case laws for every whenever you write like if you write a difference between a definition of invitation to treat or offer or acceptance, you can get the case laws from there. And if you want to, you can relevant case of law, you can copy and paste relevant case of laws. That's it. So still you have, if you have any issue or any question, please drop me an email at tutor-management at ukversity.co.uk. And you can, don't worry about assignment words, just write contents. Then first of all, you just go through the contents, then task one, then definitions, then some case laws, then task two, definitions, related definitions like here, as I can see, valid consideration and doctrine of juris, and then related case laws, and make sure the relevant case laws and references. That's it for today now. So if you have any question, please drop me an email, tutor-management at ukversity.com, and hopefully I'll see you by next weekend. Thank you. Bye.